Hello friends, in response to some comments that we had received from a previous video, today I'd like to emphasize the critical importance of increasing alimony payments from time to time. That's right, as many of you already know, alimony is a crucial pillar of financial support for those individuals who either sacrifice their careers or other financial opportunities to instead focus on contributing to their families during the marriage. Alimony is a fundamental component of fairness during the divorce process and afterwards, so increasing alimony payments recognizes and acknowledges the hard reality of recipients of alimony and what they face post-divorce in the current economic environment. Many recipients of alimony are at a huge financial disadvantage because they dedicated their time and resources to supporting their family instead of pursuing personal financial growth. So by raising alimony, it helps to bridge this financial gap between the spouse who pays alimony and the spouse who receives it. So on today's video, we are going to discuss the different reasons why alimony needs to be increased from time to time. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so let's briefly discuss some of the reasons that someone who is receiving alimony may petition a court to increase that alimony payment. And the need for an increase in alimony payments is underscored by the rising cost of living that is being experienced throughout this country. Inflation, housing expenses, the cost of medical care, and educational expenses have all contributed to a burden on the people who receive alimony, especially if they have small children who they also care for. They may not be able to cover those expenses on a monthly basis. I don't know about any of you, but every time I go to the grocery store, I cringe when I'm at the cash register and see that receipt. I also try to avoid the gas pump as much as possible. A higher alimony payment can alleviate some of these costs for the person who receives alimony. Furthermore, increasing alimony payments from time to time align with the principles of fairness and equity in divorce court. Divorce settlements should aim to provide both parties with their fair share of the marital estate. This should include acknowledging the non-monetary contributions made by the spouse who either was a homemaker or supported the career advancement of the other spouse. Now, before we get into the intricacies of how to modify alimony upward, I thought it may be beneficial to discuss some of the basic concepts of alimony. First, remember that alimony awards either appear in the final judgment of dissolution of marriage or other court order, which indicates what the alimony provisions are, or the parties may agree in their marital settlement agreement or property agreement as to what the alimony obligations are going to be. Alimony also is no longer permanent, as many of you who already watched my previous video. The Florida legislature modified the law in 2023, and it no longer allowed for permanent alimony. Additionally, some of the most contested concepts are usually, number one, the amount of the alimony payment. That's right, whether it be $500 a month that the person is paying or $10,000 a month, that can become a dispute later on, as well as the term or length of the alimony award. Is the alimony award 5 years, 10 years, 20 years? Finally, one of the issues that is really important is whether or not that alimony award is modifiable. So we need to look to the final judgment and or the marital settlement agreement or corresponding agreements to find this information. The focus on today's video is going to be modifying the amount upwards. Now, the starting point for any modification of alimony or the increase of alimony payments is always the final judgment or the parties' written settlement agreement, be it a marital settlement agreement. And what that means is if the original final judgment or the original agreement does not contain alimony provisions, so sad, too bad. add. You cannot then add alimony after the parties are divorced, because remember, the court loses jurisdiction to modify alimony if an original alimony award was not awarded at the time of the divorce. And this kind of makes sense, because if there's no alimony originally, you can't come back 10 years later asking the court to give alimony when there was never an alimony award initially. Here are where things are going to get a little bit tricky. Specifically, if the final judgment or the parties' written agreement does indeed state that there is an alimony award, if the documents say that the amount of the alimony payment is modifiable, whether it be by Florida law or some other stipulation, good news for that person, because then they may be able to modify the amount of alimony that they are receiving on a monthly basis. Now I'm going to get into reading Florida Statute 61.14, which is the statute that governs modification of alimony awards in Florida. So I'm going to go ahead and read the statute, or at least in parts. Hang in there. I know that it is not the most exciting when I read the statutes, but Florida Statute 61.14 indicates that when the parties enter into an agreement for payments for alimony, or when a party is required by court order to make any payments and the circumstances or the financial ability of either party changes, or the child who's a beneficiary of an agreement or court order as described herein reaches majority, either party may apply to the court for an order decreasing, meaning making it less, increasing the amount of support or maintenance or alimony, and the court has jurisdiction to make court orders as equity requires, with due regard to the changed circumstances or financial ability of the parties or the child, which can include decreasing, increasing, or confirming the amount of separate support. So what does all this mean? I know that I might have lost some of you, but it means that if there's either an agreement of the parties or a court order requiring somebody to pay alimony to the other, and the financial circumstances of either party has changed, or the children born during this marriage have emancipated, either party, meaning the party who's paying alimony, and in this video we're focusing on the party receiving alimony, may apply to the court for an order increasing, and in the case for someone who's paying alimony, decreasing the alimony payment, and the court has wide discretion. Because remember, family court is a court of equity, so this means that the court will consider the financial circumstances of the parties, and they may either decrease, increase, or keep the alimony payments the same. So let's give some examples of why someone who is receiving alimony may want to increase in alimony. And it starts with child support. That's right. A finding that medical insurance is reasonably necessary either for the child or the person receiving alimony, that may increase the need for alimony, as would be the cost of insurance for themselves. Remember that the cost of insurance is always skyrocketing in this country, and if the person receiving alimony now has a greater need to either cover the children's insurance or their own insurance, they may want to increase alimony. The next example is when one of the children emancipates, because when a child emancipates, then the person who is receiving alimony and presumably receiving child support no longer will receive child support. So at that point, their financial situation has changed again, and they may want to consider applying to the court for an increase in the alimony payment. Now we've reached the one that is always the fight in family court, and that is when the person who is paying alimony to the former spouse, their pay increases when they have a significant pay raise. Now, I'm not talking about the dream scenario when the person who is paying alimony, for example, wins the lottery or gets some windfall and all of a sudden they have way more income than they had when they were married. That rarely happens, but if it does happen, then the person who's receiving alimony should definitely give a shot at trying to modify the award, because it seems like it would qualify under at least the Florida statute. However, what I am talking mostly about is if the payer spouse has a significant increase of their salary due to a career advancement or other factors. In that case, then the former spouse who's receiving alimony may have legitimate grounds to request the court to modify the alimony award. However, we must tread carefully because it is a two-way street. If the spouse receiving alimony is all of a sudden gaining more income, then they are at risk as well of getting their alimony decreased. So they must contemplate or keep in mind that it works both ways, and this may be a double-edged sword. The other factor that should be considered is that, remember, court is always going to use the standard of living that was established during the marriage. So if during the marriage there was a standard of living that was a little bit lower than what the standard of living is now for the payer spouse, the court is going to compare the standard of living during the marriage, not the standard of living that has occurred after the marriage. So again, for the recipient former spouse, tread carefully when trying to go to court because of a pay increase. Another great example of a reason why to petition a court to increase alimony is a decrease in the income of the recipient former spouse. This can be from a loss of a job, being laid off, a long-term unemployment, a failed business venture, or unexpected changes in their circumstances. However, it must be noted that the court may require the recipient spouse in this situation to demonstrate that they have actively been searching for employment during this job loss or this time of unemployment. However, if the recipient spouse can show that they have, this may be a good reason to try to increase the alimony payment or the amount that's being paid every month, at least on a temporary basis. As we mentioned towards the beginning of this video, a significant increase in living expenses may provide the necessary facts or factors in order for a spouse or former spouse receiving alimony to modify that alimony award. This could include, as we mentioned earlier, the increase in the cost of rent or housing expenses due to inflation. However, the requesting party is going to have to show that there is enough in the change of their costs, be it groceries, car expenses, either for fuel or repairs, or rental expenses. They have changed so much since the entry of the final judgment that they need this increase in alimony to at least maintain the standard of living that they had during the marriage. A great example would be if a spouse is receiving alimony and 5 or 7 or maybe even 10 years later the award has never changed. It may be worth it for them to have the court look at that award to adjust for the increase in the cost of living, especially due to the inflation that we are having in this country. Finally, we are going to cover probably the most significant reason that a former spouse receiving alimony may request an adjustment of the alimony award upwards, meaning an increase in that alimony payment, and it's when there's unexpected financial hardships. And these usually come in one of two forms. One is an emergency. There's some sort of emergent health issue or disability or some unforeseen circumstances that couldn't have been contemplated before the marriage that this former spouse now has to go through, and they can no longer afford their monthly expenses. Or if there's some sort of illness, usually it's a long-term illness. If there's a long-term illness or disability that arises during the alimony award period, then obviously the expenditures of this former spouse who's receiving alimony are going to skyrocket. They have to pay medical expenses, prescription medications. They have to pay for all of the things that we mentioned in a previous video, which is divorcing a spouse that has long-term illnesses. And if this occurs after the marriage, it is often determined by a court that it is not fair that this former spouse who dedicated their great majority of the marriage contributing in a non-monetary fashion, either by raising the children or being a homemaker or supporting that spouse, for them to have to deal with this long-term illness or disability on their own without any financial contribution from the spouse that is paying alimony. So this is a really big fight, and I have a feeling that as time goes on, it's going to become even a bigger fight as our population ages. So this is one of the big ticket items when it comes to increasing an alimony award. All right, so we're about to wrap up. That's right. I know a lot of you may be asking, well, how do we prove the change in financial circumstances of either the spouse paying alimony or the spouse who receives alimony? I know that we focused on the needs changing and increasing for the person receiving alimony, but how to prove in court the change in circumstances, it's going to have to wait for a video for another day. Remember also, there's that question of whether or not you can modify the duration or the length of the alimony award. We're going to keep that one for later as well. So if any of you know anyone that may find this information useful, have them look us up at www.segarralawfirm.com. Remember, we have offices in Miami and Orlando, Florida. Se habla español. Do us a huge favor and like this video, subscribe to the Divorce Broadcast, and we will see you all soon. Thank you.